Good evening, good morning, good afternoon, everybody. I'm Avi Grossman. This is Parsha Talk. We're very happy to have with us today our special guest, Rabbi Dr. Shlomo Pill, who is the senior lecturer at Emory Law School and the Paul and Marion Kuntz Scholar in Law and Religion at Emory University's Center for the Study of Law and Religion. Wow. I hope I got that right.
A little bit of a mouthful.
What'd you say?
A little bit of a mouthful. I'm sorry.
Yes, but whatever. Also, Rabbi Dr. Pill, thank you for joining us. We are going to discuss some issues in this week's parasha, but first, I'd like to remind everybody that Haggadah Pesach's Hebrew edition, the original one, is still available for purchase and will be available for purchase until Passover and even a little bit after Passover. And the English edition is on its way. Don't worry about it. You'll have yours if you've already ordered it for Passover, God willing. If the mail is cooperating, you will have your copy before Passover also. And for those of you who haven't ordered your English copy, please do so. You can find details on my website, and I'll put that all in the description when we are done. This week we are reading about Parshat Yitro. Jethro, Yisro, however you want to call him. And I say that however you want to call him because apparently he has many names in the Torah. Rashi brings that he's also known as Chovav, Reuel, and a few others. He joins up with the Jewish people, and like a good father-in-law, he's quick to notice that perhaps Moses could use his help and his advice. And I found it very interesting that Jethro shows up in the narrative before the giving of the Torah, but apparently there are textual clues indicating that he actually showed up after the Israelites were given the Torah. Foremost among those reasons, it says that he came to visit the Israelites at the mountain of God at Horev, and it says afterwards that that's when they traveled from Rephidim and made it to Mount Sinai in Horev. So apparently he got there first and they were already there. The Torah has many instances where it's not necessarily in order. But Jethro gives Moses the idea for a system of appeals courts or just consultationary courts. The people, it's kind of interesting in Torah law. You ask someone what the halakhah would be, you technically go to his Beit Din, his house of law. And then we have the narrative of the giving of the Torah. And in the book of Numbers, we have a similar account that Moses is now asking his father-in-law, who he apparently sent off, and now his father-in-law has a different name. He's called Chovav. He's sent off, even though Moses really wants him to stay. And then we have the incident where apparently elders and others died in a plague, and Moses was bereft of assistance and appealed to God for something, some help, new elders, new leaders, to help him shoulder the burden. Many said that's the reference to the first story in Deuteronomy where Moses says that he appointed a system of courts. And you see it sort of reversed. In this week's parasha, Jethro shows up, tells them about a system of courts, and then gets on his way. And then the Jews get the Sinai, and then they get the Torah. And in Numbers, in Parashat halakhah, in the second half, it's the opposite. They're leaving Sinai, and then Jethro also leaves, even though Moses is opposed to that. And then there's a system of courts. And I've always wondered about this contradiction, or perhaps this chiastic contradiction. The Torah is full of accounts like these, but it does teach us something. And that is that perhaps one of the prerequisites for receiving the Torah is at least having a system of consultation, a system of teaching, a system of law and order and courts in order to conduct this properly. And when the Israelites left Sinai, the sages say they ran away from Sinai like a child running away from school. There was sort of a breakdown. And then you see Jethro once again is leaving, even though Moses is insisting he not. And then we have a system of courts set up, but this time out of a sense of emergency and not out of a sense of the people wanting to come to Moses for direction. He's just overburdened by so many people coming to him. Rabbi Dr. Pill, can I call you just Dr. Pill or Shlomo?
You can call me Shlomo. That works.
Okay. Yeah, you could call me Avi. So perhaps I want to know, what is the connection between the court system devised by Yisro and the subsequent giving of the law?
So I think at least one of the connections, I think, is that the court system, or the fact that a court system, the Torah, regardless of how chronologically this may or may not have happened, at the very least, Parshas Yisro, the Torah is presenting it to us as the court system happens before. And I think part of what that is communicating is something of the idea of what it is that makes Torah law. So there's a whole interesting discussion about what distinguishes a legal system from other kinds of normative systems, right? We have all kinds of normative systems out there where that tell us what to do, what we ought to do, what we oughtn't to do, how to behave, how to do this, how to do that. We have law systems, of course. We also have sort of etiquette systems. You don't put your elbows on the table, and you chew with your mouth closed. And when you drink a cup of tea, you stick out your pinky or something like that. And all kinds of other. We have rules of monopoly. Those are also a normative system. If we're going to play Monopoly, we're going to follow the rules. Everyone makes up their own rules, but they settle on some set of rules. We have all kinds of normative systems out there, and law is another normative system. And one of the sort of important or recurring questions in legal philosophy is what distinguishes law from those other systems, and why is law different? Or why do we call the law? And we don't think of laws of etiquette or rules of etiquette or ethics or politeness or rules of board games the same way. And there are all kinds of different theories about what it is that distinguishes law from non-law. But one of those things is a theory that was developed by an English legal philosopher named H.L.A. Hart in the mid-1900s. He came up with the idea that the thing that really distinguishes law systems from non-law normative systems is the existence of what he calls secondary rules. So essentially he says there are really two types of rules in the world, or two types of norms. There's primary rules. Primary rules tell you what to do. They say, or what not to do. But there are rules governing behavior. Don't write on Shabbos. Eat only kosher. Drive under the speed limit. Don't kill. Don't steal. Pay your taxes. These are behavior regulations, and they're primary rules, and we have lots and lots and lots of them. And he says that what distinguishes a law system from a non-law system is the existence of a different kind of rule, secondary rules. Secondary rules, he says, are of three types. One type is called rules of recognition. Law systems have rules that tell you whether something is or is not a rule within the system. Other systems don't really do that. If I ask you what the rules of etiquette are, you can probably give me a list of primary rules. But if I ask you how you know that that is or isn't a rule of etiquette, or if I suggest an additional rule that you disagree with, we're going to have a hard time figuring out whether this rule is or isn't part of the rules of etiquette or not. That is, so law systems have rules of recognition. Yeah. Another thing that law systems have is rules of change. There are rules governing how the law can change, and how primary rules can evolve and change and be adapted or repealed and new ones adopted and so on. And again, in secondary rule systems, we don't really have an internal coherent way of doing that. We all play Monopoly. And when we play Monopoly, some of us play by putting $500 in the free parking spot.
No. I'm a purist. I don't do that.
No, you're okay. Fine. Yeah. I disagree, but okay. Some of us play by putting $500 in the free parking spot, and some of us get an extra $200 if you land on go instead of passing go, and all kinds of other rules. And that's okay because we all happen to, all of those playing the game happen to agree on what other rules we're going to add and which of the standard rules we're going to change, and so on and so forth. And we do this with checkers, and we do this with all kinds of board games and other games. But if we didn't agree about what the rules should be, and we didn't agree about, we have a rule of recognition when it comes to board games. Maybe we have a little packet that tells us what the rules of Monopoly are. But if we didn't have rules of change and we didn't have an agreed upon mechanism for deciding how to change the rules, and in this case, it's simply by convention, those of us sitting around the board agree that these are the rules we're going to adopt or change from the standard rules, then we would be in a situation of chaos, right? We'd be playing Calvin ball instead of Monopoly. And all the rules would constantly change. And I say this is the rule when it's to my advantage, and you say that's the rule when it's to your advantage. And there's no mechanism for changing the rules. And sometimes the rules stop being useful or start having bad consequences. And we're stuck with them because we don't have a way to change them. And either then the system breaks because we stop following it because we can't change the rules and they're bad, so we ditch it. Or we start changing the rules, but without any kind of mechanism for doing so, and then it becomes a free-for-all. So the second thing that distinguishes legal systems is rules of change. And the third thing that distinguishes legal systems from non-legal normative systems is rules of adjudication. There are rules that tell you how to decide whether a rule has been broken and determine what should be done to those who have broken the rule and what penalties should be imposed, and so on. Primary rules don't do that. Primary rules just say don't murder. They don't tell you what to do when you think someone murdered. So you need other rules, another kind of rule. Qualitatively, it's a different kind of rule that creates courts, that tells the courts how to function, that tells them what kinds of evidence is and isn't good, and which kind of information establishes facts or doesn't establish facts. And if someone is convicted of having broken a rule, they can, what consequences they might face. So on some level, I think, what's happening at the beginning of Parsha Yitro is the Torah sort of letting us know that part of what makes the Torah a legal system is the fact that it has these secondary rules. It has rules of recognition, it has rules of change, and it has rules of adjudication. It has a mechanism for dealing with and making the primary rule system actually work and function in a coherent way. And I think that might be part of what's at play. And I think that that's significant because it contrasts with some of the other ideas about what makes a legal system a legal system. There are other theories about what makes law different from everything else. One theory is that what makes law different from everything else is enforcement. Legal systems are different from etiquette because if I break the law, someone with a gun knocks on my door, arrests me, and I get thrown in jail. The thing that distinguishes a legal system from rules of the game is the fact that the laws are enforced by the person with the most power. And I think this is arguable, but is a topic I've been working on for some time. The Torah doesn't actually, in practice, or at least as it's been understood by the rabbis historically, the Torah is not a system of enforceable law. It's not a system where law is enforced in any kind of regular and routine way. It is very much a system of personal or communal observance, but rarely coercive observance. And I could substantiate this with a whole long discussion, but I think historically that this is accurate, that Torah law, as Torah law, was never routinely enforced coercively in any period of Jewish history, I think. And because of that, you might think that Torah lacks the quality of a law system. But I think that part of what's going on here is that the Torah is telling us that that's actually not what makes the Torah law. What makes the Torah law is the presence of these secondary rules, and particularly this rule of adjudication. The Torah remains primarily, not exclusively, but primarily a system of private private observance. And to the extent that it involves public observance, it reflects the coming together of many private individuals. But I keep kosher because I decide to keep kosher. And if I decided to eat a cheeseburger, no one is banging down my door to arrest me.
Mm-hmm.
And don't think I think the Torah says, don't think that that means that the Torah is not a law system. It is a law system. It has all of the formal functionings of a law system. And just because it's relegated to something that in the West we would call personal conscience, doesn't mean it's not actually law. So, and I think that that's actually that's pretty important, because I think it matters that the Torah is law as opposed to something else, right? The Torah is not personal conscience. The Torah is not personal spiritual preference. It is law, and that matters because law carries a sense of obligation that these other things don't. Tangible obligation.
Can I ask you, perhaps you might be familiar with the sage's view of King Saul, for example. It says that Saul was looking for a necromancerous woman to summon the spirit of the dead prophet Samuel. And they point out there that Saul was perhaps an exception, a historical exception to what you've described, in that he was actually enforcing Torah law. And he made it that a situation whereby everybody actually had to keep the ritual law as he understood it, perhaps. And also, I would think back maybe the times of Simeon the Just or Shimon ben Shetach, where it's also described that they actually did enforce, and they're exceptional in the fact that they did enforce Torah law on the individuals, and this was something that they did in their power as, I wouldn't say kings, but as the next best thing. They were the highest ranking people in society and in charge of the legal systems and also the political systems. Would you agree with that assessment?
So I would, leaving aside King Saul for a second. I think the case of Shimon ben Shetach is a more interesting one, because there I would say we see law enforcement. But we're not seeing, and this the Talmud is explicit about, what we're not seeing is Torah law enforcement.
Okay, wait, I think, okay, yeah, explain.
Right. The Talmud is explicit that Shimon ben Shetach is acting outside of the bounds of Torah law. And he's not enforcing Torah law, he's actually enforcing something else. He's enforcing some other concern. Not a Torah concern. If he was enforcing Torah law, he would have killed each of those witches on a different day, as the Mishnah understands the Torah to require. Not that a single court can't execute multiple people on a single day. But that's not what he did. And I think that's a clue, and that entire discussion in the Talmud sort of clues us into something important. It's not that the rabbis or other authorities in Jewish history didn't enforce law. We threw people in jail, and we beat them up, and we whipped them, and we killed them for doing bad things, or for what we contemporaneously viewed as bad things. But that wasn't as a function of enforcing Torah law per se. That was a function of enforcing societal norms that we thought were necessary to have a well-functioning society. This goes to a little bit of what we were chatting about before we went live. This idea of, does Torah cover everything or does Torah not cover everything? And there's this line of thought that's very prominent in the Rishonim, in the early authorities, that says that Torah is not a good system for running a society. That's not what Torah is supposed to be doing. And we should make societal laws, right? This is in the context of relatively autonomous medieval kehilot, medieval Jewish communities, where local rulers expected Jewish communities to police themselves, and now Jewish communities had to figure out, what does that mean? How do we do that? 1,000 years after the destruction of the last independent political Jewish Commonwealth, they have to figure out what this is, and these rabbinic authorities of the time are sort of grappling with what does it mean to run a Jewish society, or a society made up of Jews? And by and large, they conclude that that doesn't mean looking at the Torah or looking at the Talmud and saying, here are our laws, this is our statute book, and now we're going to enforce it.
Yes, actually, you remind me now. Maimonides was thrust into that position in practice in Egypt. He was given autonomous control over his Jewish community, even the Karaites, on whom he imposed his understanding. And in his writings, I'm not even talking his philosophical writings or his commentary writings. I'm talking about his code. He actually includes things that you could find already alluded to in the Talmud, that the judge sometimes just has to decide things based on even his instinct or what he feels is right, and also extrajudicial impositions of lashes or even the death on people who are violating what we call societal norms. Even though he doesn't use that term, that's basically what he's describing.
Right, and of course, what we might think of societal norms today is might be very different from what they thought about were societal norms way back when. Right? If you look carefully at the way the story of Shimon ben Shetach is presented in the Talmud Yerushalmi, in the Jerusalem Talmud, the reference or the language there suggests that the complaint that was brought about the witches was that they were being machriven es ha'olam, they were destroying the world. It sounds like at least there the Talmud is communicating a sense that they presented a material temporal harm. This wasn't a function of witches are religiously sinful and evil. It was a historically historically situated but very genuine sense that witches are dangerous and they do bad things to people. And therefore they're dangerous people. They're like serial killers, right? And therefore we have to get rid of them. Whether this is accurate or not is not the point. If this is a genuine perception, then Shimon ben Shetach can be viewed as going after a band of serial killers, or at least from their perspective, not a band of sinners. Sinners are different than serial killers. Mm-hmm. So that's.
I'd like to just point out for our viewers, we're using the word Torah a lot. I found it very interesting that the word Torah already occurs with regards to Abraham. It says, God says about Abraham that he would keep God's Torahs and his commandments, that's mitzvot, and chukotai, or chukim. And we usually translate, we have a hard time translating a lot of those terms. Mitzvot is the easiest one. Those are the commandments. And sometimes we even tell kids they do something nice. Oh, he did a mitzvah. But that's not exactly what it means. The word chok, which is enactment, or sometimes we use it as statutes, sometimes gezerah, that the gezerah is a decree. That's sometimes the translation to the Aramaic of the word chok. But the word Torah itself is from the word to instruct. And the problem is that we find already that the word that you keep using, law, a system of law, perhaps the Torah is not the right word for law, in Hebrew at least. And that's why the sages in, let's say, the time of the Babylonian exile, they start already borrowing, I think it's a Persian word, the word doth. Kedath Moshe Yisrael occurs a lot in the Megillah. And you can see it's used for a lot. It's used a lot in Megillah to mean a lot of things. And one of the most prominent usage of that word is for what you and I would call law, because perhaps the word Torah itself is not a good fit for that concept. And even later in the words of our sages, we find already in the Mishnah the term halakhah, and in Aramaic halakhah, and that is, I guess, the closest word we have, perhaps the word we have for law. And that word itself is relatively new, of course, and comes from the root to go, malechet, the derech asher yelchu ba, the way you were supposed to go. But the Torah itself is not necessarily law. It's more of something you have to teach and figure out for yourself what the law would be. But it itself is not the law. What do you have to say about that?
I think yes, for sure. I think that's true. I think that it's worth pointing out that distinction. We find that distinction in other places outside of Judaism as well. For example, in Islamic jurisprudence, there's a distinction that was made that began to become prominent in the 9th and 10th, late 7th, 9th, 10th centuries, where Muslim jurists began to distinguish between the Sharia, which most people who aren't familiar with Islamic law in any particular way you often think of as being Islamic law. But they distinguish between the idea of Sharia and the idea of fiqh. And fiqh, the Arabic term fiqh connotes understanding, or something that is understood. And the distinction was that there's this big overarching religious path. Sharia is a road. There's this overarching religious path, and that includes lots of different things. It includes law, it includes ethics, it includes theology, it includes ritual observances that it includes extra legal piety and what we might call chassidut the Sharia is this much broader thing. And more importantly, the Sharia is much more abstract. The Quran is not the Sharia, and it might be a source of communicating the Sharia, and other sources might be attempts to communicate the Sharia, but the Sharia is this big, huge, amorphous thing that is identifiable with kind of the mind of God, and the path to being godly and doing things the way God wants you to. And Islamic law, sort of the rules and the principles and the practices that are prescribed as part of Islamic law, or the equivalent to what we would think of as halakhah, this gets a different name, in part to distinguish it from, to number one, acknowledge that it can only ever approximate the real thing. We're trying to figure out what the Sharia is, and we're trying to formulate rules, but those are always going to be human attempts to formulate and figure out what the rules are, that are consequences of what that path teaches us to do. So it's partly a measure of epistemic humility and saying we don't really know, but this is what we think, and if our understandings change, we have to leave open that possibility. And it's also an attempt to sort of distinguish different disciplines. Law is one discipline, and one part of the bigger picture. But there are other parts of the bigger picture that are distinctive from the law, although related to it, and they're all important. They're all integrated into some sort of whole. And I think we find similar things when it comes to how we think about Torah and halakhah, and the relationship between Torah as this sort of overarching religious vision of how Jews are, depending on sort of what your philosophical orientations are, how Jews are supposed to live and function, how the universe is supposed to function, or whatever the case may be. On the one hand, and the particularities of the law, whether rules in the Torah, in the text of the Torah itself, or rules that are developed and formulated further down the line as we try to formulate more particular expressions of what the Torah's rules require. So I think that distinction is an important one, and there are broader aspects to the Torah than just the particularities of the law, although those other things inevitably must be related to the law in some way, shape, or form as we try to figure out what we're supposed to be doing.
So here's what I'm beginning to understand in this week's Parsha, is that the Decalogue, which is the beginning of the Torah, is the first instructions that we are given, Torah, as I understand it, instruction, whereas Yitro, which is the preface, the incident with Yitro and his system, is the law, or the system of law, which has to be in place before the actual rules are given over. If I guess that's how we have begun to understand it. That is that Yitro first has to teach Moses and the people a way to communicate the whole system and its particular rules. It's like you said, I forget the term. It was like primary rules and secondary rules. Yisro first has to get the rules of the game down to us. We first have to be knowing that we're playing Monopoly, if I may use that analogy, and then we could start opening up the rule book and even deciding to add these rules, the house rules as they call them, your $500 on free parking and $200 on go. So we have a classic Rashi on a classic verse there when the Israelites first got to Mount Sinai. Moses was told to Tomar Levet Yaakov, say to the house of Jacob, V'taged li v'nei Yisrael, and tell Bnei Yisrael. Bnei Yisrael is the more common term to refer to the Israelites. This is an example, at most superficially, of biblical poetic use of parallelism. Okay, it has two synonymous verbs there, tomar and taged, and also the nouns there. The subjects are, the objects there, Beit Yaakov and Bnei Yisrael. But Rashi brings what Chazal says. Rashi says what Chazal say, which is Beit Yaakov is a reference to the women, and Bnei Yisrael, I guess, is just the rest of the men. And that's where they got the concept when they started the system of schools for Jewish young women. They called it the Beis Yaakov system. What does that teach us? What's this distinction between what the law is, because one Torah for Am Yisrael, but the communication, already we see that God himself is alluding to how it is to be communicated to the men and women in different ways. And of course, as Chazal said, for children, Chanoch lana'ar al pi darko. You have to know how to educate the child according to his own way. What does that teach us?
Yeah, so I love this, Rashi. I think this is a fascinating idea, and on a very basic level, and this is, I think, the way probably most people understand or are taught this Rashi the first time they encounter it. Well, you speak to the men one way, and you speak to the women another way. They have different ways of absorbing and processing the same kind of information, and you have to package the Torah differently in order to communicate effectively with different audiences that have different ways of thinking and processing and relating to the content that you're trying to communicate. And certainly there's something true to that, even if maybe we wouldn't draw those lines as sharply along gender lines as today as Rashi might have 1,000 years ago, but we can certainly relate, even perhaps more so now, given the way we think about education, than Rashi might have 1,000 years ago. The importance of effectively packaging what we're trying to teach in order to actually reach the audience we're trying to reach. This is sort of critical and basic pedagogy. Different audiences need to have the same information packaged and presented and taught in different ways in order to reach them effectively. But beyond that, I think that the Torah here is sort of communicating the idea that there are at least two different dimensions or two different perspectives to the law that the Jews are about to receive at Sinai. They're about to receive the law, and yet God is telling Moses, you have to communicate this law, right? As opposed to the other things we talked about in relation to Torah. But you're going to receive the law here at Sinai, and you're going to communicate this law differently because there are there are different dimensions to the law that need to be appreciated. Rabbi Joseph Soloveitchik suggested that this verse, or commented, I guess, really on Rashi's understanding of this verse, to distinguish between kind of the normative and the experiential aspects of the law. He suggested that what Rashi refers to as the way you communicate to the women is a focus on the experiential aspect of the law, and the way you communicate to the men is to focus on the normative aspect of the law. Again, leaving aside how gendered the expression is, but it's just a useful paradigm to talk about the difference between these two things. There is the normative aspect of the law, rules. This is what you do, this is what you don't do, this is how the courts work, this is how we change the rules, this is how you know if a rule is a rule. Lots and lots of rules and lots of principles. And here is a system for understanding what it is you're supposed to do and what you're not supposed to do, and everything fits in the right boxes. And it might be hard to figure out what the boxes are and how to put everything together and what it all means, but there's a system here, and some people relate to the systemization of the norms. And if I want to know how to live and what I'm supposed to do, I need rules, and I need a book, and I need rules, and I need you to tell me what to do, and then I'll go ahead and I'll analyze and interpret and apply and so on and so forth. but I'm still functioning within a normative context, a commandedness context. But
Okay,
there's another aspect. Sure.
Sorry, we have a question from an old friend.
Oh.
Before we get off track of this, you were talking about Islam before and their system. You may have seen, I think it was 2 or 3 weeks ago, we had Professor Alan Brill here. Perhaps you saw that with him. Now you have to check back on YouTube and see what you missed. Professor Brill was talking a lot about Hinduism, or what we unfortunately call Hinduism, which is a very gross overgeneralization. And he was talking about their systems. You got into Islam there. The question is there an idea in that Islamic law, among the Muslims themselves, that Islamic law is given by God, similar to we Jews believe that Jewish law was given by God?
Yes, but almost all of those terms are pretty loaded. So I say yes with hesitancy. I guess it sort of depends on what you have in mind, or what the questioner has in mind when they use the word Islamic law, and what they have in mind when they say the word given. But in principle, yes. In principle, Islamic law is under Muslims understand, or Islamic legal tradition understands that Islamic law is the product ultimately of a divine revelation of a system of norms of behavior and practice, similar to the way we think of as halakhah being divinely rooted in a revelation of the Torah.
Okay, we got a follow-up there. He says, like halakhah l'Moshe Sinai as an example. Do they have something like that? We have halakhah l'Moshe Sinai. Do they have something, I guess, like that? Or analogous, perhaps?
So they do. They have a similar idea to what we have, in the sense of a bifurcation of the law, or a bifurcation of revelation into kind of an oral and a written revelation. We have a Torah she'ba'al peh and a Torah she'bichtav. The Torah she'bichtav consists of a direct word-for-word revelation from God, with Moshe acting as merely the conveyor of the words, rather than an active participant in the authoring of those words, at least almost entirely, let's say. And we have the idea that there's a much more amorphous and less concrete revelation that goes along with it, and a Torah she'ba'al peh tradition that Moshe receives, and does come from God, but is not concretized in a text in the same way. And so by definition, it's always interpretive. There is a similar idea in Islam where the Quran is understood to be kind of the equivalent of what we think of as a Torah she'bichtav. It's literally God's words spoken to Muhammad. And Muhammad, again, acts as this passive transmitter, this passive communicator of those words without any agency. This is why, by the way, I think I'll go out on a little bit of a limb, but this is if one looks at the Rambam's formulation of his principle in his 13 principles, foundational principles of Judaism, his principle of Moshe's role, Moshe's prophecy, and Moshe's authorship of the Torah very much tracks as a response. Very much tracks Islamic expressions of Muhammad's authorship of the Quran.
Sorry, yeah, that showed up. Yeah.
Sure. Meaning this passive author, Muhammad is acknowledged as sort of this illiterate merchant who couldn't have ever written anything in his life, or authored a poetic book in his life, and Islamic tradition maintains that he's kind of this passive transmitter, the same way as Moshe is. And alongside that, there's this oral tradition. For us, it's this oral tradition of revelation that Moshe receives from God, and Moshe transmits to Aaron and to the Zakanim, and so on and so forth, teacher to student, developing as it goes along, until it finally finds written expression in the compilation of the Talmud a couple thousand years later. And in the Islamic tradition, it's what is called the Sunnah, or the behaviors, the example set by Muhammad during his life as a prophet. There's an idea that if God chooses a prophet, God chooses a prophet that won't lead people in the wrong direction. And that means by default that what Muhammad did and said while acting as a prophet is normative and instructive. And so there's a whole oral tradition that grows up during Muhammad's life about what he did in this situation or that situation under these circumstances and how he answered that question or what he taught about this or that. And there are the thousands and thousands and thousands of different traditions, teachings that are transmitted orally for several hundred years. But that's sort of a revelation that supplements and qualifies and clarifies the content of the Quran.
Mm-hmm.
Does that help? That sort of, I think, goes to part of what the question was asking. Oh, halakhah l'Moshe Missinai. I'm sorry, just one other thing, and then maybe we can get back to Parsha's Yitro. But the idea of halakhah l'Moshe Missinai. So we have this idea that there are certain laws out there, particular laws that are kind of pristinely preserved. Lots of stuff sort of gets muddled and clarified and interpreted over time in our transmission of the Torah Shebaal Peh. But there are some things, halakhot l'Moshe Missinai, that are preserved pristinely exactly as they were at the very beginning. And there are a handful of these, right? The Rambam has his count of them. It's just interesting, the Rambam's definition of how you identify a halakhah l'Moshe Missinai is sort of tautological, right? You know that something is halakhah l'Moshe Missinai if there is no machlokes about it. If there's no disagreement about what this law is, then you know that it must be a halakhah l'Moshe Missinai, that it's been preserved from the very beginning without any adulteration or misunderstandings and so on and so forth. In Islamic law, there's a concept known as ijma'. Ijma' is consensus. In Arabic, jama'ah, the root word jama'ah, it means collectivity or group. Ijma' is a consensus of the group. And this idea is which is rooted in a verse in the Quran, says that if all of the Muslims agree on a particular idea, they don't disagree about something, one knows by default that is the law. That is a form of revelation in a sense. Mm-hmm. So it's interesting that the Rambam's way of identifying a halakhah l'Moshe Missinai corresponds to this idea. And we know that tefillin straps must be black, halakhah l'Moshe Missinai. And how do we know? Because everyone knows and everyone agrees, and no one's ever disagreed about tefillin straps being black, and therefore it must be revelation, directly revealed. There's a parallel there to that concept. Like halakhah l'Moshe Missinai, there are very few halakhah l'Moshe Missinai. As well, likewise in Islam, there are very, very few things that qualify as revelatory on the basis of not being disagreed about, because everything is disagreed about.
Mm-hmm. And I guess that's the basis, what you said. You mentioned the Sunnah. That's where we get the Sunni Islam, that particular brand.
So Sunni Islam comes from this idea, comes from originally a group that was, after Muhammad dies, they try to understand and determine what Islam is all about on the basis of the Sunnah, on the basis of these traditions of what Muhammad did, as opposed to on the basis of an idea of continuing revelation through a chain of imams that still possess some level of prophecy, which is a Shia idea.
Okay. Now, we also have another follow-up question before we have to actually go. Wow, it's been quite interesting. You mentioned a system for, or at least part of the system allows for changing the law. Now, someone here was a little bit alarmed. Changing halakhah l'Moshe Missinai, or changing the Torah, is there such a thing? And I was thinking, well, technically speaking, yes, the Torah Shebaal Peh and the rabbinic system, which we assume is part of the system that we're given. I mean, that's what Moses was introducing to us by way of Yisro's advice, a system of consultation with I guess what came to be called the rabbis and the chachamim, allows for change through the midot. The Torah is expounded, nidreshet bahen, through these various means, and perhaps someone wrote Torah isn't from Shemaim. No, that's not true. Do you see that? Do you see the questions?
I don't see any of the. I don't see.
I guess only I could see it. So it says.
Oh wait! I don't have. Oh, I don't have it. I didn't have it opened. I'm sorry.
Okay, so this has basically been a Lander thing. Every communication I have is from a guy who's formerly of our base Medrash. I want to get to this. It could very well be that the system of change has been alluded to by quite a few Rishonim, and it's expounded by Achronim, that when the sages would make a drasha, certainly the Sanhedrin in sitting on the Temple Mount in their chambers would have a new drasha using these midot, that became part of the Torah, and that actually is retroactively halakhah Moshe Sinai, or at least is Torah law. It's midoraita, as they would say. So is that what you were alluding to when you say a system for changing the rules, or at least the system allows for this? Or what did you mean by that earlier?
So that's part of it. There are a few different levels at which the system of Torah law is enabled to change. One, of course, is the level of sub-Torah legislation. Right?
Yes.
To the extent to which either we have a functioning Sanhedrin, or in the absence of a functioning Sanhedrin, we have functioning local communal authorities that are duly created and authorized by the community. We have within halakhah, we have a system of creating additional binding laws that operate below the level of Torah law. You can sort of think of this as the Torah functioning as a constitution, and we have a system for creating statutes, legislation, and regulations by administrative agencies and things like that at levels below that. And of course, as we know, both from the secular law world and just living in that world, even if we're not lawyers, and also from just living in the Jewish world, the sub-Torah or the sub-constitutional lawmaking has a massive impact on sort of how we actually function in a law-abiding sense. Many of the laws that we follow operate on that level. Separate from that, of course, as you said, the all interpretation is a form of legislation. Every time the Sanhedrin interprets, every time the Sanhedrin, or once upon a time a rabbi with proper smicha interpreted or decided a question and articulated a rule to govern this case or answer this question, that is essentially an act of lawmaking, because that's a rule that wasn't there before. The reason why you're talking to the rabbi or you have a case in court is because you don't know the rule. The rule is not there. It's not clear how the Torah resolves this case. And the articulation of that rule as the case comes on is an accretion on whatever law has existed before that at a Doraita level. And now we have new law, or changed law. If we thought the law meant X before, now it means Y after this case has come up. We now know it means Y. And then there's the much more obvious and much more explicit, as we said, sort of the drashot based on the Yud Gimel Midot. And as the Rambam puts it in the beginning of Hilchot Mamrim, that sort of the Sanhedrin can function and say, yesterday ofen chalav was prohibited, and today ofen. Well, that's a bad example, but that's a bad example. But yesterday an esrog was an esrog, and today esrogim are going to be lemons. And that's a pretty substantial change in the law, and one that the Torah itself contemplates and seems to authorize.
Mm-hmm. And very interesting. Rabbi Dr. Pill, I'm very sorry that our time is winding down, but I thank you very much for joining us today. I hope, because that we have a whole host of topics we didn't get to discuss, that perhaps you'll join us some other time. I'm not going to put you on the spot. If you want to come back, you just send me a message and a PM. And we also have regards from some others that I'll give you when we get back into the green room. I'd like to remind everybody, don't forget, like, share, and subscribe. Get your copy of Haggadah Pesach, and send in your questions or comments. And if we didn't get to your questions or comments, I'm sorry, but we'll address them, God willing, sometime soon. I have to make a follow-up video just myself, because people have been asking me questions, not of my guests, but of myself. So we're going to get to those. So wait for the special edition where I'm not going to have a guest finally, and I'll be able to talk to you directly. Rabbi Dr. Pill, thank you very much once again. I'd like to wish everybody a Shabbat Shalom and a good, I wish everybody be safe and healthy. Stay away from Corona, people, and hopefully we'll get through this very soon. Be well.
Thanks so much.